but reforms in the country have made it easier for the country to benefit from all the resources that they have today. But let's go to the proverb, eh? If you close your eyes to facts, you will learn through accidents. If you close your eyes to facts, you will learn through accidents. How will you interpret it?
If you close your eyes to facts, you will learn through accidents.
Yes.
So it means that ignorance at any stage will always have consequences. That's my interpretation.
Justice.
Well, my interpretation is that do not evade realities. Once you come across a situation, face it the way it is. Otherwise, if you evade it, then you are going to learn through the hard way, through an accident, or something serious is going to happen that you may regret. So face facts as they come. Yeah.
I hear him say, "Ima kona tuache." Straight as it comes. Well put, well said.
Yeah. Right.
Yeah.
Fantastic. Our Justice Thursday conversation today is around the prosecution of juveniles. We'll go through some definitions, but it's interesting that as of June 2023, 1,019 children were held in various centres around the country, including children rescue centres, remand homes, reception and assessment centres, and rehabilitation schools across Kenya. Separately from this 1,019, 225 children under the age of 4 are held in prison with their incarcerated mothers. We know that children are not held in prison with incarcerated fathers, only with mothers. Interesting. We can talk about that as well. This is according to data from 2022. And in 2023, the number of children committed to prison for criminal offences was reported as 418 girls and boys for that year alone. So those are some numbers that we're looking at. And maybe to come from the argument from the very beginning that we shouldn't have children in prison, we shouldn't. Okay, so let's look at what the law says, and let's look at the situation that we're currently dealing with in the country when it comes to the prosecution of juveniles. For purposes of definition, and we can start with you, Honourable Choi, what or who is classified as a juvenile in Kenya today?
Thank you very much. When we talk about juvenile prosecution, basically we refer to children who are above 14 years. The age of criminal liability in Kenya is above 14 years. So if you are below 14 years, then you are not criminally liable.
Okay.
So when you talk about juvenile prosecution, we talk about children between the age of 14 to 17 years.
Okay.
Yep.
Okay. And do we see, Bwana that these who are classified as juvenile, and we're going to take this number of 418 just for this question.
Okay.
The 418 who are serving prison terms for criminal offences, we see that they actually committed these crimes, went through a trial, then were convicted, sentenced. Is that the situation that we would see for these 418?
Yes. So, as Honorable Cho has mentioned, and as the definition of juvenile, the word juvenile, unfortunately, has a very negative connotation. And our recent law, the Children Act of 2022, it changed the language that we use to refer to children in the justice system. And for juvenile offenders, it then called them children in conflict with the law. So that then there is no this negative connotation of a juvenile. You know, a juvenile in our society, someone who's committed the worst of offenses while a child. So to just improve the dignity of how we serve our children in the justice system, we call them children in conflict with the law. You've spoken of the number of 418 of children who have committed various offenses.
That are actually serving in prison.
Sentences.
Yeah.
So that study was done in 2018, just before we had the Children Act of 2022. And before the passage of that act, unfortunately, the act that we were using was the Children Act of 2001, which unfortunately had various gaps that had been identified, and which led to quite a high number at that time. So yes, children have previously been taken to court, prosecuted for various offences, and the number has continuously and progressively reduced over the years, because of various progressive provisions in the law. For example, the issue that he has mentioned, the increase of the age of criminal liability. Before the passage of the Children Act, the age of criminal liability was 8 years old. Right now, it's 14. So you can see, previously we were prosecuting children who are now between 8 to 14. They used to find themselves in the justice system. Now, a child who is between 8 to 14 is taken as a children in need of care and protection from the law, and therefore does not serve a criminal sentence in a children remand home or a children facility.
Okay.
Yes.
What are these children serving for in terms of the offences? What are the offences that we see that children are committing that would then hold them criminally liable? Honourable Joy.
Okay, thank you. There are several offences that lead to these children finding themselves in prison. Most common are these petty offences. But before I can even talk about these offences, most of the children who are in these institutions are the ones who have committed a little bit more serious offences.
Okay.
So some of them, you will find cases like robbery. There are children who have been found guilty of offences of robbery with violence, stealing, burglary, cases of drug abuse, trafficking in drugs, and such related cases. But for petty offences, there are petty offences like stealing things, maybe being found in possession of stolen property. So some of those ones, normally they are not sent to prison.
Okay.
But we have alternative forms of sentence, not necessarily prison terms.
Allow me to ask, of those that you've mentioned, the one that under the penal code is seen as a capital offence is robbery with violence.
Yes.
Right?
True.
So would you deal with a child in conflict with the law who is charged with a capital offence of robbery with violence in the same manner that you would with an adult?
We
under the penal code.
Okay. Actually, for children, we do not use the penal code.
Okay.
So the way we treat children, we use the Children Act.
Yes.
Under the Children Act. Of course, the offence is under the penal code. But the way we treat them,
yes,
we are guided by the Children Act.
Okay.
So there are several procedures when we are dealing with children. So number one, we must ensure that these children have legal representation. So that is number one. A child cannot proceed with a case, a serious case, a capital offence. In fact, any offence in court without having the services of an advocate. So in that regard, we have pro bono advocates. If the child is not able, or the parents are not able to afford an advocate, we have services of pro bono lawyers who then advise this child through the process of litigation. Number two, we ensure that the children, the space where this case is conducted, is child-friendly. The courts where we conduct these matters, they are child-friendly. We ensure that these children are protected The matter is done in privacy. It is not reported. We ensure that it is expedited. We do not want children cases staying in courts for too long. So those are some of the measures that we take to ensure that the manner we deal with these cases is not the same as the cases that we against adults.
Yeah, so we look at the Children's Act of 2022, and if you look at its focus mostly is to be child sensitive. That is the direction, right?
Yes.
And here now we look at approach being, focus is not to imprison a child, So it is a question of looking at rehabilitation, education, and reintegration, not purely punishment.
Yes.
And if that is the approach, what one would just ask, what have we seen that is changing in terms of the numbers now that are going down? Mm-hmm. How has that changed how we deal with such cases in court?
Okay. Some of the beautiful provisions that have led to the numbers going down include, as he has mentioned, the access to justice for children, ensuring that all children in our justice system have legal representation. And towards this, the judiciary, through the pro bono advocate scheme in all children courts, has set aside funds to ensure that these advocates that are representing these children are remunerated so that they are able to offer quality access to justice. The other beautiful provision is that we have at least 2 gazetted children courts across the country that ensure that the matters of children are adjudicated in a friendly setup. And even in other courts that are not gazetted as children facilities, we have child-friendly facilities that are set aside for just hearing of children courts. In regards to litigation, the Children Act has also ensured that litigation is only as a measure of last resort. There are processes that before we even start the litigation of a case, there are processes that guide us just before we proceed to litigation to ensure that the matter can be resolved in any other alternative except going the full trial. So these processes include pre-charge diversion, where before a child is taken to court, the prosecution together with the police can agree that a matter can be resolved through diversion. And there is also something, once the child has been taken to court, something called a preliminary inquiry. So the preliminary inquiry is supposed to guide the court on the nature of the offense, the circumstances leading to the commission of the offense by this child, and what is the best alternative to resolve this matter other than the court. And if all these instances, the diversion by the prosecution pre-charge and the preliminary inquiry then suggest to the court that then we proceed to full litigation, then that's when we proceed now to the child taking a plea and the matter going to full litigation. So you can see there are safeguards that ensure that our children do not end up in the justice system. And even when they end up there, there are provisions. Now we are even thinking of developing regulations for the Children Act for children in conflict with the law to ensure we set a set timeline for how long children matters should take in court.
How long should they take in court?
Right now the regulations are not there, but practically we suggest that between 6 months to 1 year maximum.
Okay. If we deal with the Children's Act and not necessarily the penal code for some offences or any other part of the law, we deal with the Children's Act specifically, how then do you decide how the punishment for a child who is in conflict with the law? I'm going to have to get used to that phrase. Who is in conflict with the law, but according to the justice system, it deemed it necessary to punish or to seek retribution. How then do you decide what is an adequate sentence, punishment, if you're not dealing with the law, but you're dealing with this special group of people, which are children?
Thank you very much. I think what happens is that, the court has a lot, wide discretion when dealing with the children. And as Lewis, my friend here, said, before it has been decided fully that now this child will go through the criminal trial process, a lot has been done. and a decision has been arrived that yes, this one should go through this criminal process. So the court will hear the matter, and when it comes now to the kind of sentence that is going to be meted, then the court has got a lot of discretion. And this discretion is based on several factors. So normally what the court does is we act with the several stakeholders in the justice system. We cannot do it on our own. So what we do before we do any kind of sentencing, we will involve children officers, we will involve probation officers. So this probation, the work of these probation officers, they will write for us what is called a pre-sentence report. So this report, it comes up after they have interviewed. They will do several interviews. They will go to the place where this child comes from, the society within which this child lives. They will interview the parents, the neighbors, the community, or even the school, and get background information about this child. And from this report, they are going to make a certain recommendation based on their findings. So probably you'll find that this child committed this offense not because maybe they wanted to commit it, but there are underlying factors that led to commission of this offense. For instance, this is a child probably was not able to get food, and the only way to do that was maybe to steal something from somewhere. Or this child is in a place where he or she is exposed to a lot of crime. So you find early exposure to crime. So once we read these reports, we are able now to decide what kind of sentence to pass against this offender. So in most cases, there are several kinds of sentences that we meet, depending on, of course, on the situation. Some of them include probation. You can do actually a probation sentence. So you sentence someone to probation. So that means for a period, maybe 1 year, 6 months, without committing an offense, conditional, that within this period, do not commit a similar offense. But if you commit an offense, a similar offense, then a serious sentence is going to be meted. You can send this person for community service. You can even reprimand, as simple as actually even reprimanding. The law even provides sending this child to the community or a parental guidance. So there are several options that the court has. So it actually depends really on the particular circumstances leading to the commission of that offense.
You've talked about when you're going through the judicial process, there is need of looking at the background. And the reason why I zero in on looking at the background is because there's a paper I was reading, I'll just quote, that many juvenile offenders come from vulnerable backgrounds, poverty, broken families, informal settlements. For example, informal settlements were identified as crime hotspots for juvenile offenders. There's a report that is out there. And having this at the background as this being the hotspots, we will go through the judicial process, fine. The child will get probation, no? But after they are out and they have been cleared to go back and reintegrate with the society, which is a great job that you've done, how then would we ensure that this child does not come back then to court? So there is need to deal with the problem where it is. So if it's broken families, how are we ensuring that that problem is sorted out? If this child comes from informal settlements where the early exposure, as Honorable Ochoa has said, early exposure to crime, this child has been exposed. How do we deal with that so that as we are reintegrating this child back to the society, we have dealt with the problem that landed them in court at the first place? How do we approach that? I know it's complicated, but it is a conversation that includes government agencies, to deal with that problem. How is it?
Okay. So as you mentioned, and rightly so, is that this requires a lot of multi-stakeholder engagement. And this month, for example, November, is classified by the judiciary as the Child Justice Service Month, where they get to address all child justice issues in courts. And through the same, for example, we have a good community awareness campaign with the Milimani Children Court in Nairobi, I believe around Resambu, because we have identified Resambu as a hotspot of children coming into the justice system. And when we are going to the community, we are going to talk to the community about the issues that we are facing in court with the children that are coming from that locality and the type of offenses that they are committing. So we are talking to the community about how, one, they address, so that because a child has found himself into the system, it doesn't mean there are not other similar children in the same community with the similar issues, only that they have not been arrested, or even this one that we are releasing back into the community may relapse and come back into the system, and therefore we must tackle it at the community level. And therefore we go to the community as one big body, the judiciary, civil society organizations, the police, the children officers, to have a multi-stakeholder engagement with the community themselves, community members themselves, and talk about how do we live with our children. How do we make our children not end up in the justice system, especially during holidays? Because we've also noted that crime committed by child offenders spike during holidays. So, and especially now, it's a very long holiday. November and December, children are at home, and in informal settlement, that could be a trigger to children finding themselves in the justice system. So we're just talking to the community about how they prevent children going into crime, what are the avenues that children could use, because some of these things are also contributed by children lack of positive hobbies to do in the community. So we just requires us to go to the community, talk to the community, and use platforms such as this to talk to the community about how to prevent children coming into the justice system, and even ensuring that when they come into the justice system, there are measures in place to make sure that they don't end up back into the justice system. For example, a child has committed an offense of robbery with violence. The contributing factor was bad influence or the environment where they come from. So how do you manage their integration? You manage their integration through the probation officer's report, which will, of course, highlight that there were issues around bad influence. So how do you talk to the parents to ensure that this child stays away from bad company or is safeguarded in the home? How do you talk to the chief, to the community leaders to ensure that the children do not engage in negative behavior? So it's a whole spectrum of issues, but in summary, it just requires us to have continuous engagement with our community leaders and our parents to ensure that our children don't come, even teachers in schools, and keep our children active in positive hobbies.
So are we saying that the goal or the desire is to not have children pass through the justice system?
I can say actually that is our desire, and that is the ideal situation. We would not want our children to go through this justice system, and that is why the New Children Act is very clear that before a case starts in court, the first mention or the first appearance in court for any child who has been brought, who is in conflict with the law, the court must conduct a preliminary inquiry. That is number one. That is a must. It is a condition. So this preliminary inquiry is basically to find out, as my colleague here said, does this child have to go through the justice system? Is it necessary? Are there no ways? Is there no other way we can deal with this child apart from taking him through the justice system? So that is the ideal. In fact, the Children Act emphasizes on that, and all courts are actually required to ensure that this preliminary inquiry is done, and then diversion is done. So the ideal position is to have diversion.
Okay.
And I understand even that the DPP have a diversion policy to ensure that children do not go through the justice system.
Okay, can we look at a dicey one here? And that is sexual offenses. All right, we know that the age to then give consent is 18
Yes.
in Kenya.
Yes.
And we have seen cases where two children engaging in sexual activity is deemed an offense
Yes.
and then can then be equated to rape. If both of them are under the age of 18 where they can give consent, we have actually seen where in some cases the male child is then accused of having committed a sexual offense. How does that work in today's system, whereby we have many cases of this happening, where some have gone through this, pre or outside of the court settlement kind of thing, where families have spoken to one another? Justice Odunga, in that landmark, ruling or pronouncement, said a number of things about what he would like to see happen. But the minimum sentence in this case is 10 years for a child, even. How do we deal with that, with all of this that we've spoken about so far?
Okay. So, you've brought up a very interesting and a juicy issue. So, in our communities today, the reality is that our teenagers and adolescents, some of them are engaging in sexual activities.
Yes.
That is the reality that we are living in today's world. But our law tells us that the age of sexual consent is 18 years.
Yes.
But our children are still engaging in sexual activities. How do we deal with this issue? So in judgment in 2017, Justice Helen Omondi pronounced herself on this matter and said that when two teenagers or two minors engage in sexual activities, they've actually committed an offense against themselves. That is, in instances where there was no use of force or coercion by one child against the other. These children have committed an offense against themselves. And the offense they have committed against themselves is called defilement. Because you have engaged in sex with a person below the age of 18 who ideally cannot give consent. But how do you proceed? Do you proceed to prosecute these children, both the girl and the boy, in a criminal court? No. The best scenario is to take these children as children in need of care and protection in what we call a Romeo-Juliet scenario.
Yes.
These are just teenage lovebirds who've, because of their feelings and because of their biological inclinations.
All right.
Have led them towards some of these things. And therefore, by them being taken as children in need of care and protection, the court then can then direct them and recommend that these children be taken through a comprehensive sexual education counseling, so that they understand why it is an offense for you to engage in sexual activities before the age of 18.
Where you can give consent.
Yes.
Yeah.
So instead of charging them now in a criminal court, you take them through an alternative, which is a protection and care case, where the court then puts certain minimum requirements for a children officer to be able to follow up on these children to ensure that they actually attend these comprehensive sexual education counseling classes and give a report back to the court that these children have actually been attending and there have been noted progress. And these are only for first-time offenders. For second-time offenders, then the court then takes a harder stance that now we gave you an opportunity when you were first brought to this court and we told you that it is wrong for you to engage in sex before the age of 18, but it has been reported that you have been brought here a second time at that time, and therefore you must now proceed with this as a criminal charge.
Okay.
I look at a situation where, in terms of repeat offenders, so here's a question where first time I've gone through the court process, gone through probation, reintegrated back to the society. And then a little bit later, a second case again happened. And at that point, how does the court handle that? You said it's a harder stance on that. What does a hard stance mean in the court of law?
Okay. This is basically we are talking about a repeat offender. So what does that mean? That means the initial sentence, the purpose of the initial sentence, for instance, if it was meant to reform. So that means that the purpose was not achieved. So when the person is brought again now to court, can you meet the same sentence once again. I think you cannot, because what you did at the first instance did not achieve its goal. So now you give an alternative sentence, which is a little bit higher than the first sentence, right? So if, for instance, he says maybe they were sent out under the care of a probation officer, under probation, but they repeated. Now the next one, you don't give a sentence of probation. You can give an alternative sentence, maybe a fine or community service, kind of work, some community service. So at least to feel that, yes, indeed, I think what I did is wrong, and I don't want to repeat this offense again.
Where do we see most cases? There's a question that has just been asked in terms of juvenile cases that we see, rural versus urban. Where do we see most cases, and why would that be the case?
Mostly in our urban areas. If you check the numbers of crimes in Nairobi, Mombasa, Eldoret, Nakuru, many of our major urban centers is where most of our children are engaged, are caught up in criminal acts. In rural settings, I don't know whether it's an issue of underreporting or lack of systems, but mostly it's in our urban areas.
What kind of support systems then are in place? Because we do know that the judicial system or process works, with many friends of the court, as it were, right? So you talk about community service, you talk about psychological training and or counseling and things like that. We know also that because of the Children's Act, you have homes, you have places, and you have practitioners. How is that system supported through the judicial process, whereby we're saying, okay, well, this is not a child who needs to be locked up in a remand center for the next 10 years. This is somebody who maybe needs some attention. This is not somebody who needs to be locked up. Maybe this is somebody who needs to be assured of basic rights like 3 meals a day, right?
Sure.
This is not somebody who needs to be locked up, but maybe this is somebody who needs to be assured of love and care. When we talk about them like they're foreign ideas, but these are children.
Yes.
So what support does the system have to ensure that it's not just throwing them in the slammer and throwing away the key, but that there are folks who can come into the process to help out with some of the issues that are causing them to commit these offenses in the
I work for an organization called Pendekezo Letu. And Pendekezo Letu is a civil society organization that works closely with the judiciary and other actors to ensure that we work to prevent children from going into the system. And this is done through various activities and programs that we have in the community, including child rights sensitizations in schools, child rights sensitizations for street-connected children in the streets, training of and capacity building of justice actors, because as much as we have very good provisions in our laws, we must also realize that many of our actors, that is police, pro bono advocates, children officers and probation officers, still lack capacity and understanding of these beautiful provisions that we have for our children. And these are the people who have been given the responsibility by law to implement some of these good provisions. So if you do not sensitize them and improve their capacity and understanding of some of these provisions, then it becomes a challenge. So Pendekezo Letu also assists in the capacity building of these actors. As I had mentioned earlier, we are also supporting a community awareness campaign. And this is not our first time we are doing this. We had a very beautiful launch for the Service Month in Mathare, just to go and take the practitioners out of the court system and engage with these children in their localities and get direct questions from the children and the community about their lived realities on the ground, about police harassment, about lack of proper structures at police stations to hold children. Because when you go to most of our police stations in our informal settlements, they're not friendly to our children. Children are still being put in adult cells. Children are still being beaten up by police officers. Children are still being denied key services, identity documents, and some of these things we know the lived reality in our slums is that without an identity document, it then becomes a risk to you as a child, and you can be easily arrested and linked to various crimes. So as a civil society organizations, we support the system to go to the community and talk to the community and understand the community needs, so that even as we sit in court and as we sit in boardrooms to make policy about how we are going to protect our children, we have gone to these people and talked to them about their lived realities in their communities.
What are the challenges that you face, Honorable Ochoy, when dealing with these cases that come through, and where does judicial discretion play in all of this?
When we talk about challenges, especially in children cases, one of the major challenges we still face is the fact that even though we are now talking about diversion, we still find that I think there is lack of awareness, as he has talked about. There are people who do not understand that these are children and we need to treat them differently. So there are many people who come to court and insist that we want these children go through the justice system. They do not understand that the children should be treated differently. One other thing is, I think even the stakeholders in the justice system, not all of them have embraced this fact that children need to go through diversion. So you will find that in some cases, even when handling these children when they are arrested, you may find children being arrested alongside adults. Sometimes they are taken to police stations and kept in adult cells. Sometimes they are kept in police stations for too long before being presented in court. And sometimes when they are brought to court, one other challenge is maybe finding advocates to represent them. So that process sometimes is not seamless. It may take some time to identify an advocate to represent this child. So you may find this child now maybe spending in custody for some time before getting this advocate.
Yeah.
Another challenge, basically, sometimes is when this maybe child is brought before the court, getting that background information. Where does this child come from? Because we have said we need to understand the background of this child so that you decide on how to pursue the case. So sometimes, like the children who are found in the streets, so sometimes it is not easy to get their background information to enable us now to give appropriate directions on how to deal with this with this child.
Honorable Choi, I want to look at a situation where it's only 14 years and 18 who can appear in court.
Yeah.
But I'm looking at a case where, assuming it's a matter that has been committed by a child who is below the age of 14, and clearly you look at it and it's a serious matter that needs the court's attention, or it needs to be addressed by someone. And say it's a parent who's brought this matter in court or has come for advice. How do you approach that? How do you have this conversation? Because one would say, regardless of what has happened, this is a crime that needs to be addressed. How do you go about that? And then when you talk about challenges that you face, we know infrastructure is a problem. And even when the Act 2022 was coming up, one would have hoped that with these Act being in place, infrastructure and other supporting mechanisms would have been put in place. And you talk about street children, whenever they're picked, I remember it was around 2021 when street children were picked in Nairobi and they were dropped in cells, How do you go about these issues to just ensure that justice is dispensed as enshrined in law?
Okay, thank you. In regard to acts committed by children who are under 14 years, so the Act says that between 12 and 14, the circumstances surrounding that case can be brought before the judicial officer and may interrogate the circumstances. And if the judicial officer is convinced that, depending on the circumstances, that the child understood or understands what was happening, then the provision, the child actually can also go through this system between 12 and 14. But from 12 downwards, below 12, it is said that that child cannot be charged at all. He does not understand what a crime is. A crime is.
So they can't be charged.
They can't.
So there's also the assumption that in the commission of that crime, they were unaware of the impacts of their action.
Sure.
They didn't know what they were doing.
They didn't know.
Okay.
That is what is presumed. And alternative ways now will be used to deal with it. Maybe the parents of both, maybe the child, the parents of maybe the victim, they can talk and see the best way to handle that matter. But not through any justice system.
And additionally, the Act also allows for opening of a protection and care file for such cases. So, for example, a 9-year-old has committed the offense of murder, but they cannot be taken to court. And this is a lived reality, because we had one case that was in the news. A child was 9 years, stabbed another one, and this led to the death of that child. So what can happen in that instance, because you cannot open a criminal file, you open a protection and care file, which then addresses these other surrounding circumstances. What led to this offense? What are the needs of the victim's family? How do we ensure that this child is protected? Because leaving this child in that community is also a risk to this child who committed this offense. So how do you address all these needs? And therefore, the protection and care file, because it's opened by the prosecution in a close collaboration with the Children Office, takes consideration of all those surrounding social factors.
Okay. So if that's the case, then do we have any children in remand centers? And I don't even know if we still call them remand centers, approved schools, who are under the age of 14, one, and then what are approved schools, remand centers? Where are these children sent? Are there children who are in adult prisons like that?
So the Children Act only recognizes 3 institutions. A children remand home, that is a place where children above the age of 18 who have been charged with criminal offenses are placed. There's a children rehabilitation facility, or a children rehabilitation center, where children who have been taken through various processes, probably a protection and care file or a criminal file, and the final decision of the court has been that these children need some form of behavioral rehabilitation, and they're taken to a rehabilitation center. The other one is a Children Boston Institution. A Boston Institution is now higher than a rehabilitation center. It's like a minor prison where it focuses on more correction than punishment, but for more serious offenses, for crimes for a child who has been committed for a sentence of more than 4 months.
Who are the custodians in these centers? Who are the people who are taking children through this rehabilitation, retribution? I think that's important, isn't it? Because if you're trying to say at the end of the cycle that a child should come out, having learned something, then it's very important to note who is the person who is in the position of oversight.
Okay, so the children remand homes and the children rehabilitation facility, majorly most of them are under the care of Directorate of Children Services, and at the Boston institutions, and are under the care of the Kenya Prison Service. And majorly, as I have said, it focuses on rehabilitation, and most of the officers in these facilities have been trained by civil society organizations, by state, on rehabilitative processes of handling children in conflict with the law rather than punishment, so that we do not end up with a child who is in a Boston institution which is under the care of a Kenya Prison Service officer who was previously in committee and is dealing with a child like we will deal with a prisoner at committee maximum prison. So there has to be some sort of special training on how to handle the rehabilitation process of such children.
Just to Choi, like infrastructure, as I'd asked before, continues to be a problem. So not just in children courts, even in the centers that you talk about, continues to be a problem. And this then would come into the National Treasury, national government, and allocation of funds to be able to address this. Are we seeing a situation where with this act now in place, there has been any movement in ensuring that if it's the court, you're well sorted out to ensure that these matters are handled better? And if not, what should we do?
Thank you very much. And I think that brings me even to the theme of this month's Children's Service Month. One of them is increasing funding to combat child abuse. So when we talk about funding against child abuse, we basically are advocating for funding and funding from government. Of course, the judiciary has always been asking for more funding, and also even our stakeholders, the people whom we collaborate with in the criminal justice system, in order to increase funding. We are happy to work with many groups, like their group, for instance. There are several activities that they conduct, like the awareness. So, there is a lot of funds that they put into some of these activities. So it is not only from government, but funding also from other institutions, well-wishers who can work with the courts. Yeah.
And additionally, to ensure sustainability of these programs, as you mentioned, the Children Act had a lot of good provisions on improvement of infrastructure. But the unfortunate thing is that it did not come with an implementation framework, which will then have directed budgeting to some of these things. But progressively, we've seen an increase and the improvement of the allocation of resources towards some of those things. For example, we did not have a specialized child protection unit in the police service. I understand that now we have one, and probably over the next financial year, we are going to see them spread out in most of our police stations. I can also say that in many of our police stations here in Nairobi, because that's majorly my area of practice, also we've seen that many of them have set aside some special place where they hold children. Sure. So we are seeing some improvements. Of course, it's slow, but we are seeing improvements.
Yeah, and actually, even to add, even on that,
this is the Situation Room, the only way to start your day.